Welcome to this explainer. Today, we're unpacking an upcoming UK immigration rule change that is honestly a total game changer for families with mixed immigration statuses. If you've ever dealt with the UK immigration system, you already know the drill. It's incredibly precise and, frankly, sometimes pretty unforgiving. But today, we're zooming in on a very specific update for children of British or settled parents. We're going to see how a seemingly tiny tweak in the rules is opening up a massive new settlement opportunity, and why understanding the nuances here is absolutely critical if your family is affected by it.
Okay, let's take a quick look at our agenda. We're going to cover four main things today. First, the new UK settlement opportunity. Second, the March 2026 problem. Third, and this is our main focus for today, why exactly children qualify for settlement under these new rules. And finally, we'll talk about why this is likely a very temporary window.
But before we get totally lost in the legal weeds, we have to ask the million-dollar question driving this whole analysis. Could this actually allow more children to qualify for indefinite leave to remain? Now, indefinite leave to remain, or ILR, is the ultimate goal, right? It means permanent stability in the UK. And the short answer here appears to be yes, but the reality is completely tied up in strict timing, heavy legal criteria, and the very real chance of future government rollbacks.
All right, jumping into Section 1, the new UK settlement opportunity, focusing on those crucial August 3rd updates.
So timeline-wise, we are basically sandwiched between two critical dates. We've got a sudden tightening of the rules in March 2026, and then this upcoming vital relief hitting on August 3rd, 2026. The Home Office made some moves in March that caused quite a stir and seriously complicated things for a lot of people. But now, they're introducing new wording set for August 3rd. It is a wildly tight timeline of change, flipping from a major restriction to a huge potential opportunity in just a matter of months.
You know, it's crazy how in the incredibly labyrinthine world of UK immigration law, literally one sentence or even just a tiny shift in phrasing can mean the difference between securing your family's future or being stuck in bureaucratic limbo forever. A small change in the rules is about to create a seriously important settlement opportunity for some children. This upcoming August update is a perfect example of how hyper-specific legal wording directly alters real lives.
Moving right along to Section 2, the March 2026 problem and its unintended harsh consequences. To really get why August is such a big deal, we have to look at the mess created in March.
Back in March 2026, the Home Office set a really harsh baseline. Basically, they required both parents to be British or settled before a child could get ILR. If only one parent was settled, the child normally had to prove that parent had sole responsibility. And let me tell you, that is an incredibly high bar to clear. But the August 3rd reality flips the script. It revises the wording to reopen the door where just one parent is British or settled, even if the other has limited leave, provided there are serious and compelling reasons.
Just think about the mechanics of this for a second. An unintended consequence of those March rules actually penalized the child of a British citizen simply because of their partner's temporary status. As the quote says, they faced stricter requirements literally just because the other parent held limited leave under a UK visa. It made getting ILR absurdly strict for these specific mixed status families.
Okay, let's jump into Section 3. This is the absolute core of our explainer today: why children qualify for settlement. Let's strip away the background noise and break down the specific criteria taking effect on August 3rd.
So how exactly does a child qualify for settlement starting in August? It basically boils down to three main conditions. First, one parent has to be British or settled. Second, the other parent has temporary immigration permission, which the Home Office calls limited leave. But here's the kicker. The third condition is the absolute key to qualifying. Serious and compelling reasons must exist to grant the child indefinite leave to remain. It's no longer just about existing in a mixed status family. Those first two steps just get you to the starting line. Step 3 is the actual race. If, and only if, all three pieces align, the door to settlement opens.
Now, families absolutely must prove those serious and compelling reasons exist. The Home Office demands really strong evidence as to why this child needs ILR right now, instead of just waiting for both parents to settle. This isn't just checking a box on a form, it's a massive evidentiary mountain. You might need to prove severe disruption to the child's life, critical health needs, or major educational impacts if their status stays temporary. Clearing this specific, rigorous hurdle is exactly why and how a child will ultimately qualify under these new rules. Which brings us to our final part, Section 4, temporary window for families, and the absolute need for immediate action. Here's the scary part.
This new wording, it might actually be interpreted a lot more broadly than the Home Office originally intended. And if you follow immigration law, you know exactly what happens when the government feels a rule is being utilized too widely. They issue immediate clarifications or just outright amend the rules to slam the loophole shut. So this opportunity created by the August 3rd wording could be highly, highly temporary.
Because these applications require such persuasive proof, families who think their child qualifies need to take 3 vital steps immediately. First, get specialist legal advice. The stakes are way too high to fly solo in this shifting landscape. Second, prepare early. Time is not on your side, and we honestly don't know how long this wording will last. And third, gather undeniable evidence of those serious and compelling reasons. Without that mountain of proof, the application is going to fail.
I'm going to leave you with this one giant unknown hanging over the whole situation. Will the Home Office issue a clarification before August? It's a sobering reminder of just how precarious this window really is. An amendment could drop at literally any time, changing the calculus entirely. So, understanding these rules today is absolutely your first step to securing your family's future tomorrow. Thanks so much for joining me for this explainer. Keep a close eye on those updates, and I'll catch you next time.